Well, welcome everyone. I'm Jason Rantanen, a professor at the University of Iowa College of Law and director of the Iowa Innovation Business and Law Center. It's my great pleasure today to introduce and welcome Professor Shubha Ghosh, the Crandall Melvin Professor of Law and Director of the Technology Commercialization Curricular Program at the Syracuse University College of Law. Dr. Ghosh earned his JD from Stanford University with distinction in his PhD in economics from the University of Michigan. Prior to joining Syracuse University School of Law, Professor Ghosh taught at the University of Wisconsin College of Law. Professor Ghosh's extensive research focuses on the development and commercialization of intellectual property and technology as a means of promoting economic and social development. He's published extensively on pharmaceutical design, copyright protection, competition policy, and intellectual property issues beyond that, as well as antitrust law, legal construction of the marketplace, technology transfer, and the role of intellectual property law and policy in shaping these diverse areas. He's also one of the co-authors of this fantastic Hornbook mini treatise, Understanding Intellectual Property Law, that I find super useful. Today, Professor Ghosh will deliver a talk entitled Promoting Equal Protection, Congress's Remedial Powers Under the Copyright and Patent Clause. He'll speak for about 40 minutes, and then we'll have some time for questions. You can type your questions into the Q&A feature on the Zoom webinar, and he can answer them at the end. So with that, welcome, Professor Ghosh.
Great. Well, thank you, Jason, and thanks to everybody at the University of Iowa. Thanks to Sarah Clark for making everything happen behind the scenes. I've been following this seminar series since I think it was launched last summer. I've really enjoyed, I think I've been to every one. I don't know, I'll say I have, and Jason can correct me. And I've really enjoyed all the presentations. I'm really proud to be part of this, and I hope I make a contribution. I'll be making reference to some previous presentations as well in my own presentation today. So thank you, Jason, and thanks to everyone at Iowa for making this happen. I'm going to talk about scholarship relating to the IP and social justice movement, I'll call it that, and specifically focusing on constitutional law issues. I think some issues that have been overlooked but are probably should have been addressed in this scholarship. And specifically, I want to talk about the interaction between Article 1, Section 8, Clause 8 of the Constitution that gives Congress the power to enact patent and copyright statutes, and the 14th Amendment, specifically Sections 1 and 5. And the main points that I want to get across today in the next 40 minutes, and then hopefully through discussion, and hopefully there'll be some follow-up through email and discussion offline as well, is to situate the current IP and social justice scholarship within the Equal Protection Clause and congressional powers. And specifically, I want to develop a framework that looks at the triangle of law, policy, and politics to understand the constitutional dimensions of the big policy and political debates that are happening. And the central point that comes out of this that I think hasn't been talked about as much, except for some very fascinating work by Professor Jessica Silby that I'll also make reference to, that Congress has remedial power under the Patent and Copyright Clause, consistent with Supreme Court IP precedent. And specifically, I want to talk about the case of Golan versus Holder. Professor Silby talks about other cases, and I'll make references to them as well. But largely, the discussion about Congress's powers under the Patent and Copyright Clause centers around the meaning of progress. And there's a lot of literature on what progress means within that clause, having not only sort of an industrial development, growth, efficiency, wealth maximizing dimension, but also an equality dimension to it. But I also want to add another aspect to this, and I'll talk about this briefly, and that is the word secure. What exactly does securing exclusive rights within Article 1, Section 8, Clause 8 mean on its own terms, but also within the context of the 14th Amendment? So let me first situate all of this within what I refer to as the IP and social justice movement, IP and social justice scholarship. There's so much. I'm not doing it justice here in the draft paper I have. I think I try to do as good a job as possible to cite all the scholars. And I want to focus, though, on three groups of scholarship the welfarist, the critical theory, and Rawlsian lines of scholarship. And I just mentioned a couple of the papers here as I'll make reference to them in my talk. Within the welfarist school, what I call the welfarist view, which is largely growing from an economic theory of social welfare that involves both considerations of efficiency and equity and fairness within traditional economic terms. You have a very important article by Lisa Cook that came out in the Journal of Economic Growth a couple of years ago that's getting a lot of press regarding the role of violence and patenting within the African American community from 1870 to 1940. Professor Cook is an economist at the Michigan State University, and she's been active very recently on some reform proposals coming out of the Brookings Institution regarding the innovation ecosystem and specifically reforms to the patent system to try to remedy some of these past injustices that I will be talking about. Peter Pinnell's work on mapping intellectual property social justice frontier is forthcoming within from a book by Latif Matima and Steve Jamar at Howard University. And these both represent, as I say, a welfarist approach. There's also the approach of critical theory. Anjali Vats has gotten a lot of attention for her work on color of creatorship. She's got a very interesting article recently on the work of the singer-performer Prince within her framework of Black capitalism, as she uses the phrase, that draws on Fred Houghton's work on fugitivity, and I'll talk a little bit about that later. Audra Savage, and I should point out that Anjali talks about critical race IP as sort of driving the school that she's working and developing. Audra Savage, who spoke a few months ago in this series, talks about critical race corporate theory, and she had a very interesting presentation on racially offensive trademarks and the responsibility of corporations to try to remedy past practices. Kevin Green writes about race rights and reversion, talking specifically about termination rights. And these scholars fit into a critical theory that I will refer to jointly a little later on in my slides. And then finally, there's the Rawlsian approach that has some overlap with some of the others, but really draws upon the work of John Rawls in terms of his theory of justice and some of his later work to understand specifically copyright and its role in promoting a Rawlsian theory of justice. So this is sort of the IP and social justice scholarship that I'm referring to. And there have been a bunch of empirical findings that come out of this scholarship, as well as other work that I want to make some reference to, because these set up sort of a record for the kind of exercise of remedial power that I'm advocating for in this presentation. I won't go through all of these findings. I will highlight my paper. My draft paper will go through this in more detail. But Professor Cook, for example, had looked at empirically looking at a time series of patenting among African-American inventors from the 1870s to the early part of the 20th century. And she found, for example, that extrajudicial killings, a fancy way of saying lynchings, and loss of personal security depressed patent activity among Blacks by more than 15% annually between 1882 and 1940. Very striking, her findings are the activities or the drop in patenting activity after the Tulsa race riots in the early part of the 20th century. And she also found, among other findings, that patenting activity was lower in states with more riots and laws promoting segregation than in other states. So I highly recommend her paper. I'll be glad to take any questions of it, the best that I can as a reader of that paper. But I highly recommend people to actually read the paper, and I'll talk about some of her reform efforts that are building upon that empirical work. There's also empirical work that I think many of the audience may be familiar with from Brownice and Oliar, Schuster et al., basically looking at racial and gender disparities among inventorship, among trademarking, among patenting. And I summarize those here. The Spectre and Brand article that's at the very last bullet point here was from the Landslide magazine from, I think, last fall or last summer. And they found, for example, that women account for only 11.4% of patent practitioners having a technical background in electrical engineering, and only 11.1% of patent practitioners having a technical background in mechanical engineering. We find similar disparities within the trademark system, and this is a paper that I recommend from Professors Markowitz, Britton, Gerhard, and Schuster that I think was presented last summer at one of the workshops and series that we're zooming about. And they find, for example, in the trademark, the disparities are kind of opposite of what you might expect. While women and minorities have been underrepresented historically, the disparity is decreasing at a rate not seen in other IP registration systems. Our analysis also reveals that female applicants regularly secure trademark registrations at a higher rate than men, and not all racial minorities are underrepresented in the trademark applicant population. And what their research shows, I think, and I think I allude to their policy reference in the next slide, is something about the structure by which patent, copyright, and trademarks are granted to be one of the reasons for some of these disparities. And these disparities seem to go in a different direction within the trademark system, because as I understand one of their kind of policy conclusions, that the role of discretion is very different in the trademark registration process than in the patent prosecution process. So there are many reform proposals that come out of this literature. I summarize some of them here, and I'll make reference to them later. In the Markowitz, Britton, Kaplan, and Morris paper on unregistered patents, they suggest that there should be a system of unregistered patents, much like there is a system of unregistered trademarks, in order to deal with what may be called systemic bias in the grant of patents. But there are other recommendations as well: anonymous review of copyright and trademark registrations and patent applications, implicit bias training. I underlined some of the things here. I won't go through all of them. I'll refer back to some of these proposals, specifically improved STEM education for women and minorities, improved access to financial resources for women and minority entrepreneurs, addressing the gender and minority gap in patent applications and the patent grant rate, and the practice of trying to include inclusion riders in entertainment contracts, something that got press attention at the Academy Awards a few years ago from, I believe it was Patricia Arquette's acceptance speech at those awards. I'll refer to all of these very generally throughout my talk, and then look at some of these more specifically as I try to place this within the framework of law, policy, and politics that I'm going to talk about. So I will talk about the law, but in order to understand the law, we need to understand also the policy debates, and that is sort of the normative inclinations, the advocacy behind which we think about legal reform and how particular doctrines and cases have to be changed. But we also need to understand the implementation of these policies within the law, and that's what I mean by politics. And by politics is not just simply legislative change, obviously electoral change, changing maybe the structure of the Supreme Court, these types of structural remedies. I'm also thinking about private orderings, what happens in the boardroom, what happens in the contracting process, what happens, which if you think very broadly, as IP civil rights activism, if you want to make that analogy. And that's also a very big part of how we understand these proposed reforms. So if you think about the civil rights movement, I read John Lewis's Walking with the Wind a few months ago, and there's a lot of discussion there about, obviously, the Selma March and the civil rights demonstration, the civil rights protest. But he also spent a lot of time talking about how that related to what individuals like Thurgood Marshall, individuals like the ACLU, and others were doing within the legal process. And so this is the spirit in which I'm thinking about this framework of law, policy, and politics. And let me look at each of these boxes separately while thinking about how they interact as well in understanding the IP and social justice agenda. So when you're thinking about the legal aspect, we start with the constitutional text. We have sections 1 and 5 of the 14th Amendment. We have the Commerce Clause. We have the Necessary and Proper Clause. I can make reference to this. I'm not going to do a rehash of sort of the foundational constitutional law principles, but I will talk about some of the cases in the next slide that follow from these constitutional provisions. And what I'm trying to add to the mix in this discussion is Article 1, Section 8, Clause 8, copyright and patent clause, to understand how that also has a remedial dimension. That applies not only to how we think about intellectual property reform, but might also have how we think about the 14th Amendment and other areas, especially when we're thinking about things like affirmative action in education, or even policies of employment and government contracting in intellectual property institutions. So if you're thinking about the basic foundational case analysis under the 14th Amendment and the Commerce Clause, the basic case regarding racial disparities, California versus Johnson, most recently talking about strict scrutiny for racial classification, United States versus Virginia, where there's heightened scrutiny. I would argue it's strict, but there's a debate about how strict it is. But certainly it's above intermediate scrutiny for gender classification. And then you have the city of Bernie versus Flores, which talks about Congress's exercise of its Section 5 powers. And that is relevant in the city of Bernie case, it's relevant to religious freedom. But this would also be relevant if Congress starts enacting legislation to try to correct, for example, disparities in intellectual property licenses, or try to impose some system of remediation for past disparities in intellectual property royalties. And so the city of Bernie versus Flores talks about a congruous and proportionality analysis in Congress's exercise of its Section 5 powers. Basically, Congress has to have a record, which is why the empirical work that's being done, that I made reference to one of my earlier slides, is so important for us to try to understand what the underlying record is against which we understand IP reform. Also important is to understand what's happening at the state level, where we do see, at least in I think in my last count, about 6 states that have enacted referendum that basically take away any type of racial or gender preferences. Very broadly, we can talk about them as affirmative action. I've been trying to avoid that term for reasons I can get into later. But the Schwett case has had to do with a Michigan referendum that basically removed affirmative action in education. The Supreme Court basically says these are allowed. The 14th Amendment does not prevent state limitations on affirmative action in education. California had Prop 209 that went beyond just simply education to also employment and government contracting. And I believe Arizona, Colorado, and a few other states also have similar state law provisions. And I think it's important to recognize this because a lot of what we're talking about in terms of remediation does involve state law matters, contracting and so forth. And if we do understand Article 1, Section 8, Clause 8 as having a remedial aspect to it, I think that opens up, and I'll talk about this very briefly, but this probably is a subject of a separate paper, the possibility of preemption. With these types of state statutes that limit remedial measures, affirmative action in various aspects, be somehow limited when they apply to IP remediation. So I just sort of bring that out, why I think that's an important dimension of developing Article 1, Section 8, Clause 8 as a remedial power. So if you're thinking about, again, the law, background law, before I get to Article 1, Section 8, Clause 8, several contextual cases that's important to keep in mind. Largely where the law is heading is that if you do take race or possibly even gender-based remedial action, whether it's correcting past discrimination in employment, affirmative action in education, or correcting past discrimination in government contracting, there has to be a compelling interest and there has to be narrow tailoring of the remedial power to what the harm is. And so I won't go into these cases. I can talk about them in more detail, but these are fairly familiar cases. Washington versus Davis having to do with disparate impact claims in the employment context under the 14th Amendment. Ricky versus Stefano having to do with remedial action to try to avoid disparate impact claims in government testing or promotion policies. And then everybody's familiar with Grutter and Fisher from our own work and what we've seen in legal education. And we'll see what happens as far as the Harvard case, which I understand there has been a cert petition filed with the Supreme Court in terms of that policy. With the current court, especially on the education front, we've seen a bit more accommodation of affirmative action. Justice Scalia in the Fisher case really argued there's no compelling government interest in favor of affirmative action in education. And with the current composition of the court, I expect some of these earlier cases, Grutter and Fisher, to alter. As I'll talk about in a previous slide, what Grutter and Fisher refer to as sort of diversity as a compelling interest. And a prediction, I'm not saying this is going to happen, is that with the current composition of the court, the 6-3 composition, there would be a majority to basically overrule Grutter. And that's fairly important, again, for how we understand Article 1, Section 8, Clause 8, because that creates other compelling interests beyond diversity. And as I'll see in one of the slides, there's been a very big criticism from all sides about diversity as a rationale. But if you're thinking about innovation, if you're thinking about some of the policies under Article 1, Section 8, Clause 8, those can be very important to keep in mind. I want to emphasize and highlight the Adiron versus Pena case here. Very important case on the 14th Amendment, partly because it got rid of this two-tiered view of Congress's power that the court promoted in Metro Broadcasting just a few years before Adiron versus Pena. In Metro Broadcasting, the court said that for benign racial classifications, the standard would be one of intermediate scrutiny, but for hostile or animus-based racial classifications, the standard would be strict scrutiny. Adiron versus Pena basically got rid of that distinction and said strict scrutiny across the board, even if it is a benign classification. And the court in Adiron versus Pena, Justice O'Connor's opinion, talks about skepticism, consistency, and congruence in developing race-based classifications. Now, Adiron versus Pena is also a very interesting lesson because there is a big discussion about whether, just because we have strict scrutiny, whether that means a remedial plan is fatal. The 10th Circuit did ultimately uphold the remedial plan. The case did get the 10th Circuit decision in 2001 was heard by the Supreme Court in oral argument, but then the Supreme Court withdrew the grant of cert as improvidently granted. So there's an interesting story there. But the 10th Circuit decision on remand from Adiron versus Pena, the Supreme Court decision here, did uphold a revised version of the remedial plan. So I think this is important to point out because strict does not involve fatal. And so as I try to develop the arguments for Article 1, Section 8, Clause 8, one of the purposes for my doing that is to try to think about other compelling interests that can guide these remedial measures, not just simply in the intellectual property space, but I think very possibly in other spaces that are related to the intellectual property space, such as education. So let's talk a little bit then about Congress's remedial power under copyright and patent clause. There's a lot to say here, and I recommend Professor Silby's article in the Chicago Kent Law Review, and also her forthcoming book. I think the manuscript is circulating, where she has a lot more extensive discussion of this. But Golan versus Holder is the case I'm going to talk about. There's language there. The language from the court talks about ameliorating accommodations. And if you remember in that case, the court basically upheld a congressional scheme that revised certain copyrights that had fallen in the public domain because of disparities in the U.S. treatment of non-U.S. artists and creative persons. And so the idea here is that Congress was compensating for past inequity in U.S. copyright law. This was done, of course, in the context of international obligations. And just as an aside here, I haven't really talked about international aspects, but I think that's very important to see how this might fit. What I'm talking about here would fit into TRIPS, as well as some developments within the EU on correcting past racial discrimination. And so if we think about this congressional power that arises, we can see implications also for other aspects of IP law that also have a remedial nature, such as termination rights, such as patent term extension, and so forth. I want to also talk a little bit about, and I can do so more in Q&A because I want to get onto some other issues, how the necessary and proper clause fits into this. One of the immediate criticisms of what I'm talking about would be, well, all Congress can do under Article 1, Section 8 and Clause 8 is sort of create property rights. It just secures exclusive rights. But I want to think about this in conjunction with the necessary and proper clause of Article 1, that this may go beyond just simply creating rights to resolve also inequities in contracting, inequities in hiring, and inequities in access to IP institutions. And I think, this Article 1, Section 8, Clause 8 argument that I'm trying to develop here would also have some implications for the state referenda limiting preferences that I discussed before as a possible policy preemption discussion or analysis for those state statutes. Okay, another dimension that I want to spend some time talking about, and I don't think has gotten any attention in the literature for what I've seen, but I'd be very happy to be corrected about this. A lot of literature about what progress means in Article 1, Section 8, Clause 8, but what about the word securing? The securing exclusive rights simply mean granting those rights. Why not just simply say granting those rights to get into a little bit of textualist discussion here? And so we know there's legal issues of securing rights for those who do commercial law. We talk about security interests for those who do corporate law. You talk about securities. So the word secure has a lot of dimensions of meanings. If you look at the language of the Constitution, I did a quick search a few days ago. You see the word security in the Second Amendment as meaning protection of the state. I don't know if that's largely relevant for Article 1, Section 8, Clause 8. You do see the word secure as an adjective in the Fourth Amendment as meaning security of the person. That's kind of interesting if you're trying to think about some of the overlap between the Fourth Amendment and some aspects of intellectual property. But I think what's really interesting is the use of the word secure in the preamble, where the Constitution talks about secure blessings of liberty for ourselves and posterity. Everybody remembers that from the Schoolhouse Rock, if not from the actual text of the Constitution. I actually went back and found it in the text of the Constitution. And I think it's interesting to think about the language there, the use of the word secure there, in conjunction with securing exclusive rights in Article 1, Section 8, Clause 8. Now, obviously, I have to do a lot more homework and a lot more research. I'm just making a very one-shot textualist argument here to make the point that when they talk about securing exclusive rights, it is going beyond just granting rights, and we're talking about actually grounding and protecting the exclusive rights on principles of liberty and equality, and that can include rights that have become insecure because of inequities in contracting practices and other inequities in the marketplace by which these rights were transferred, bought and sold, and so forth. Okay, so let's now get into some of the policy aspects under the 14th Amendment. These are well played and obviously come up again in dealing with some of these remedial policies that I talked about in the earlier slides. You have the color blindness, self-help type approach that really, to quote Justice Roberts here, the only way to stop discriminating about race is to stop discriminating based on race. Of course, that gets into a whole load of discussion about what exactly does it mean to discriminate in the various ways that Justice Roberts is using that word. But you do have the color blindness rationale. And ultimately, we're thinking about a world where, of course, we know that race is a fiction. We know these are sort of social categories. But we also know that color blindness does not mean really color blindness. It means sort of a default that has certain hierarchies and presumptions with them. We also think about self-help. I mean, I think self-help has also another dimension to it that can involve the civil rights activism that we think about. It can involve the Black capitalism that Professor Votz writes about in her interesting article about the artist Prince. But also it has the sort of strict capitalist government stay out view of self-help that I assume more of the conservatives also mean. I think that interplay is really worth thinking about. What I think is often ignored by those who talk about strict color blindness are issues of empowerment, are issues of representation that are important for understanding what remedial powers are under 14th Amendment and other provisions of the Constitution. When we're thinking about policies in the IP remedial space, we're worried about wealth accumulation. This has been a big issue in terms of real property. Professor Thomas Michelet at Texas A&M has written about this in terms of the dilution of property interests among African-American rural communities. This also can be a big issue, of course, is a big issue when you're thinking about wealth accumulation in the entertainment industries. There's also the anti-subordination principle, where we are thinking about strict equality among different performers, among different groups of artists. And then pluralism. I use the word pluralism consciously here rather than diversity as another very important policy dimension in this space. Finally, politics. How does the politics dimension fit into this? And here by politics, I do mean action outside the law. I don't mean illegal action. I'm talking about the kind of activism that we saw in the civil rights movement, going back to the formation of the NAACP, and then throughout the 30s, 40s, 50s, 60s, and so forth. Professor Golubok's book on the lost promise of civil rights talks about a pro-labor aspect of the civil rights movement in the 30s and 40s. That's worth thinking about in terms of how the politics of the civil rights movement made a shift, really a class-oriented shift, as I understand the argument, from focus on labor to focus on things like housing and education and so forth. Professor Orofsky, a political scientist, I think he's at the American University, most recently had the affirmative action puzzle that talks about really how affirmative action, I've avoided the phrase affirmative action and used the phrase remediation, even though that also has some limitations on it, but partly because of the politics associated with affirmative action. But Orofsky does take a very affirmative view of affirmative action, going back to its roots and talking about how, despite some of the backlash, it's a very vibrant concept that continues within the political activism that underlies the legal cases that I've made reference to. Very interesting is the work of sociologist Frank Dobbin, and I think his co-author, Alexandra Kalev. Professor Dobbin, I believe, is a sociologist at Princeton, and Alexandra Kalev is at Tel Aviv University. And they are looking at corporate policies regarding diversity training and look at some of the limitations of that policy. One important point to keep in mind, I think in their analysis, is that a lot of corporations are sort of floundering. And by corporations here, I mean, they also include discussions about diversity, inclusion in universities. Largely, we can think about the strand that I have here in the lower left corner as sort of this private ordering approach to dealing with remediation. And their point is that a lot of this is floundering because of lack of direction from the Supreme Court. That the Supreme Court, makes some very broad pronouncements about diversity, but doesn't give any specifics, other than to avoid things like quotas or what things might look like a quota. And so they do a very good job in terms of how the corporations have tried to, and private holdings, I'll use that phrase, have tried to accommodate these types of issues. But I think the title of their article from Harvard Business Review says it best: companies need to think bigger than diversity training. And here again, Article 1, Section 8, Clause 8 might provide, if you understand that clause fairly openly, fairly liberally, and it's not just simply about industrial progress or some 19th century notion about progress, but involving pluralism, involving expansion, involving some notions of equality, can also provide that bigger when we're thinking about how private orderings pursue this, as well as when we're thinking about congressional and public reforms. And I also want to recommend Nancy Lyon's book, which is sort of in the spirit of her approach, is a little bit more critical about identity capitalists and how diversity gets misused in terms of trying to pursue goals of curing inequality. Okay, so how about the politics and then IP remedialism? How does that fit into this? This is where we see the various dimensions of what I had before in my previous slides, where you had a welfarist approach, you have the Rawlsian approach, and then the critical approaches. You have the political liberalism. I think the Rawlsian approach would fit into this political liberalism type approach. And what I mean by that is we need just stronger laws. If we try to do this, we can reach Rawlsian notions of justice through race and gender neutral rules. There might be some, obviously some necessity for more inclusion in the patent bar and other IP institutions, but things like termination rights and race and gender neutral statutes are the way to go. And that's how I interpret some of the Rawlsian arguments that you see, for example, in Hughes and Merges. You have the critical approach. I find the notion of fugitivity, which goes back to Fred Houghton, that Anjali Watts touts, as actually very persuasive. I mean, this whole notion of on-the-ground activism, political and market-based action in terms of trying to promote remedialism. Professor Watts, in her book, does talk about, with some skepticism, legal reform. And I don't want to overplay what her points are, but I think it is important to think about how political activism, economic activism does play a role in how we think about this. And I think Rawlsian notions do lend themselves to that as well. If you read things other than the theory of justice, for example, political liberalism, Rawls did struggle with these questions of, how do we look at politics? How do we look at markets? And not just, in terms of implementing the various principles that he talks about in a theory of justice. I mentioned Professor Silby's book. I think in the chat, there's a cite to her forthcoming book. And I view this as sort of IP civil rights. Again, not to limit or categorize it in a misleading way, but it is trying to think very broadly about the spirit, not only of civil rights activism, but of the lawyering that we see in the civil rights movement. I'm attuned to what George Cohen talks about radical pluralism in his critique of Rawls. Cohen's use of the word radical pluralism is a little bit odd in my opinion, but I talk about that in the draft paper. But I do think we need to think about these multiplicity of approaches in how we think about remedial action, not just simply in the IP space, but in this space more broadly. Okay, so I have about, I think I'm going to give myself maybe 3 or 4 minutes to take advantage of the full 40 minutes promised to talk about some remaining slides. And this is about assessing specific policies. So within this framework of law, policy, and politics, how do we understand these specific policies? Where might they go? How do they favor and so forth? I'm not ranking them. I'm just trying to say, here's the framework, and now we can go back and think about some of the reforms that are being touted. So we look at race and gender neutral policies. I think many of these would survive. I mean, these fall within the box of political liberalism in the previous slide, but they would pass, I think, 14th Amendment muster because they fall within, to look at it from the far right, the conservative standpoint, sort of a colorblind approach. Unregistered patents, anonymous review of registrations and applications, copyright terminations and formalities, diversity training for IP practitioners. These would all be sort of neutral policies. I think the problem is I don't know if they go far enough in terms of the kind of remedy that would be needed. So when you're thinking about race and gender-based policies, we need to think about diversifying the IP bars, and those would take remedial action, the kind of traditional affirmative action type policies that go back to the Roosevelt, Truman, Eisenhower, Kennedy, Johnson administrations. And we have the employment law precedent that can guide us in terms of how we think about these approaches. And I think there's room within this precedent for having these types of policies to diversify the IP bar. Diversifying STEM education for racial and gender inclusivity. This is a very interesting one, especially when we're thinking about where Grutter and Fisher may be going. Certainly within those schemes, we think about diversity as being a very important rationale. And I think certainly, having policies, we think about pipeline policies, but you also have other types of policies, whether it's a 10% rule or other types of rules or approaches that admissions committee takes in order to diversify education. Certainly those fit into what Grutter and Fisher allow. Again, if the Harvard case goes up to the court, and if what I imagine the 6-3 court might do in terms of overruling Grutter and Fisher, who knows? But that's why it's important to think about Article 1, Section 8, Clause 8, in terms of thinking about these other dimensions of why we want to undertake this type of remedial action, and how they might interplay with the 14th Amendment in terms of creating both compelling interests that go beyond diversity and as well as the narrow tailoring that maybe a more conservative court would demand. Now, we know that Justice Barrett was a Justice Scalia clerk, Gorsuch and Kavanaugh are Kennedy clerks. So I don't know if they follow in the footsteps of their mentors, of their previous bosses. Justice Scalia, I believe it was in Grutter, said there is no compelling interest. I don't know if Justice Barrett follows that line, but certainly if we see Kennedy's approach continuing, maybe even in a more relaxed, more liquefied approach, there may be some arguments to be made beyond diversity in that realm. Okay, so other areas, again, I'm running a little bit out of time that I talk a little bit about when we're thinking about Congress's copyright and patent powers. You have things that I've mentioned, promoting progress in science and the useful arts as a compelling interest, as well as broader aspects of the IP clause that I've suggested in how we understanding the word securing. Inclusion riders are very interesting in terms of understanding contracting and other private orderings. And let me just make some quick reference to other work that I've done. For example, my book on identity and invention, talking about the Black patient in the Nitromed patent or the Black body in custom fit patents. I think these race-specific clauses in patents probably would survive a compelling interest of strict scrutiny type analysis, but I'd be glad to take questions about that. I presented this paper a few weeks ago at Professor Gabrew's conference at Duquesne, and somebody mentioned that, I don't know at what conference that somebody had touted, I won't go into the names here, about whether there should be a gendered or racialized non-obviousness standard in patent law. I don't think that would survive constitutional scrutiny, even under what I'm proposing, that there isn't really a compelling interest here. And more importantly, that would not, and even if there were, creating a separate non-obviousness standard for women and African-American inventors would not be narrowly tailored. So I think there's a lot of analysis here that my framework opens itself up to, and I hopefully have given you a flavor of this. My goal here is to think beyond progress. That when you're thinking about Article 1, Section 8, Clause 8, there's a lot of discussion about the policies behind that, but we need to look at the language that not so much rejecting the notion of progress, certainly rejecting a very narrow notion of progress that largely is based upon 19th century industrial progress or certain strands of Enlightenment notions of progress, to a more broad, inclusive notion of progress that also involves us looking at other aspects of Article 1, Section 8, Clause 8, such as the word securing. I'll end there, and hopefully that this has been enlightening as to what I've been up to, and I look forward to any discussion. If we don't have time to get to your question, please email me at my Syracuse work address. So thank you again, and thank you, Jason, and I'm going to stop sharing.
Thank you, Professor Ghosh. That was really interesting. If you've got any questions, you can feel free to type them into the Q&A function in the Zoom webinar. You can write them into chat and send them to us that way. I've got a couple questions myself
Sure.
as I'm listening to you and thinking about this. So my first question is what does the IP clause get you that the Commerce Clause does not? In other words, why would we want to use the IP clause? Why isn't the Commerce Clause enough to achieve the goals that you're describing?
Yeah, partly is sort of the backlash to the Commerce Clause. I mean, I think that's a great question in terms of the interplay between the Commerce Clause and the patent and copyright clauses. What about trademarks? What about trade secrets? I think looking at some of the Commerce Clause cases, there has been some issue, especially when we're thinking about the city of Bernie type cases, in terms of how far you can go with the necessary and proper clause under the Commerce Clause cases. So in some ways, we're still under the shadow of the 1870 civil rights cases. I mean, despite Katzenbach versus Morgan and Katzenbach versus McClung in the 1960s, there's still a lot of skepticism about how far Congress can go with the Commerce Clause. I think what Article 1, Section 8, Clause 8 adds is, and I think it's just beyond rhetoric, but certainly it introduces at the minimum this rhetoric of innovation, of promoting progress in the sense of having a diversity of products, opening up markets, opening up entrepreneurship, those types of things that we think about as coming out of Article 1, Section 8, Clause 8, that we see articulated in cases like Golan. Now, let me just add one thing here that's getting a little bit beyond your question. I picked Golan, but I've tried to avoid Eldred because I don't want to seem like I'm coming back and trying to take a revisionist approach to Eldred. I think Eldred is just wrong on its facts in terms of how it reached its decision. And I think, Professor Stobie does talk about Eldred in terms of sort of an equality jurisprudence, and that's fairly interesting. I think, what Eldred ignored was sort of equality between authors and non-authors. I think there's a discussion about equality among a class of authors, but it simply ignored that aspect of equality, and that's what I find a little bit disturbing about Eldred. At the same time, the background discussion in Eldred regarding, promoting innovation, promoting new works, and going beyond promoting new works to creating new markets, entrepreneurship, that spirit, if you will, and I don't want to overplay it. I think that's something that Article 1, Section 8, Clause 8 adds that the Commerce Clause does. And I think that's particularly important when you're thinking about the education context. I don't see the court buying anything I'm saying. Let me just be very honest about it. But I don't know. Maybe I can magically have the court that I would like. But I think in terms of just the academic debate and the politics of this, things might filter out or filter up once we think about this issue about remediation more broadly than just simply in terms of the Commerce Clause and the traditional way in which the 14th Amendment jurisprudence has gone.
Thank you. I've got a related question, which is, let's say we're focusing in on the IP clause here, right? How do you deal with the argument that it's about securing for limited times to authors and inventors the exclusive right? I mean, some of the things that you're talking about seem broader than securing for limited times to authors and inventors the exclusive rights to their writings and discoveries.
Yeah, so I guess there are two things. One is, the role of the necessary and proper clause in all of this, that in terms of securing for limited times, there may be certain actions that go beyond just simply establishing the right for a certain fixed period of years. So, for example, termination rights. I mean, how do we understand termination rights? To take that example, I don't think anybody is challenging termination rights. In fact, there's a lot of arguments that they should be expanded, or at least that model being used for other forms of remediation. Well, termination rights, I think, are an example of securing in the sense of the rights existed at one point, but because of the inequities in the marketplace, Congress gives the copyright owner another bite at the apple, so to speak, in terms of renegotiating those rights. Maybe that can be justified under the Commerce Clause, but I think that would follow from two ways. One is necessary and proper under Article 1, Section 8, Clause 8, as well as I think the word securing. Again, I don't want to make too much of a word, but I think there is something there beyond a textualist argument. And that's something I've been thinking about. I'd like to go, and if anybody has done research on what the word securing means, I'll be very happy to see it. I make an analogy here to securing in the preamble, but I don't think that's too far-fetched. I mean, the way in which the word is used here, even though it's done in conjunction with creating limited times, also suggests that even if, I'm not talking about creating a perpetual intellectual property right. I'm just saying those particular rights as created needs to have a firmer foundation, and that can include remediating past inequities and how those rights had been exercised. Does that answer the question?
Yeah. So I have time for one more question. So what you talk about in terms of progress, it reminds me, it draws a lot of parallels to the progressive movement of the early 20th century and the conceptions of progress then.
Yes.
How do you respond on the originalist, or how would you respond to an originalist on the meaning of progress tied to progress in 1787, 1789?
Right. Yeah. Well, I mean, I read Mala Pollock's work on this. I think about a couple of decades ago now, hard to believe. But I mean, I think the word progress, as I understood her article, simply meant originally progress in the way John Bunyan uses it in the book Pilgrim's Progress, getting from A to B. Now, does getting from A to B mean that it's teleological, which is sort of more of a 19th century Darwinian notion? I don't think that was the original conception of progress. And so it is simply about getting from A to B. And I think what A and B means, I think originalism doesn't really tell us. I mean, that has to be filled in with, whatever Congress, through the interplay of policy and politics, says A and B means. But I think that's largely what was the originalist definition of progress, and it was fairly open-ended. It was trying to think about a dynamic notion about why we're creating these rights. In other words, movement, without necessarily thinking. So one way to think about this is maybe within natural rights. I think you can understand natural rights also has a dynamic notion of rights, but it wasn't thinking about sort of these pre-political notion of rights that are being recognized. It was meant to be a very instrumental notion of rights. And I think that's also consistent with an originalist understanding of this. What the ends and means are, I think, are still open-ended within an originalist framework.
That seems especially true in the context of science and the useful arts, where your future point at any given point in time is going to necessarily be changing over time, and we've recognized that certainly within what kinds of subject matter can be encompassed by copyrights or patents, right, as that expands over time. So that is necessarily a moving target, it would seem like.
Yeah, I mean, just think about last week. We landed on Mars and we started disseminating new COVID vaccines. I mean, those are very different useful arts, different types of knowledge. Did all of that within a week, right? So, but yeah, there can be lots of different ends, lots of different means.
Terrific. Well, thanks again, Professor Ghosh.
Thank
I really
you.
appreciate you joining us today.
Thank you again.
Next week, we'll have Professor Lisa Fairfax, who will be speaking as part of our Innovation Business and Law Center Speaker Series. So I hope you can all join us then. Bye-bye.
Thank you. Thank you, everyone.